Good morning, everyone. I, Advocate Nilesh Borate, welcome you all on behalf of RERA Practitioners Association, Pune Study Circle. Today's webinar is on amendments to Maharashtra Co-operative Societies Act with reference to housing, which will be presented by eminent advocate Shantanu Khurjekar sir. And he will be sharing with us his expert opinion on the topic. I request Advocate Amit Patil to please introduce our speaker.
President
I request
Mr.
Amit sir,
Nilesh Borate.
Amit sir, your voice was mute
Hello.
previously. Will you please start the introduction again?
Okay. Hi all. This is Advocate Patel on behalf of RERA Practitioners Associations Pune Study Circle under the guidance of our President Mr. Nilesh Borate and our core committee members. Warm welcoming Advocate Shantanu Khurjekar sir, who is a very popular and eminent personality in cooperative court Pune. He is a very he is a very well versed with all civil, cooperative, consumer, DRT, NGT, especially in cooperative laws. He is also delivering lectures in various cooperative education institutions as like Padma Shri Vicky Patil cooperative institutions to guide the people in the said departments. So now I'm requesting Advocate Shantanu Khurjekar sir to take over a charge and give us a very valuable webinar on topic as discussed earlier. Thank you, sir. Hello, sir. Hello.
Shantanu sir?
Sir, are you there? Hello. Khurjekar sir? Hello. Hello. Hello, Khurjekar sir? Nilesh sir?
Yeah, I think he must be having some technical problem. We'll wait for a few minutes just.
Yeah.
He was there. He had
Yeah.
joined the webinar. We'll just wait for a few minutes.
Okay.
Amit, you continue till then.
Hello.
Amit. Hello, Amit.
हाँ ma'am.
Till then you continue.
हाँ
You
ma'am.
can tell. You continue, please, till then. Amit. Amit, unmute yourself first.
Yes. Yes, ma'am. Now I'm. I think my voice is audible now.
Yes. You can continue. Okay.
All participants are requested to stay soon. Webinar will be started as soon as possible. There is some technical difficulty over Khurjekar sir, but Khurjekar sir will be live as soon as possible. Please stay connected.
Yeah, I just had a talk with Mr. Khurjekar, sir. He'll be online within 1 or 2 minutes.
Webinar will be started shortly. Please stay connected. Very warm welcome to all the participants. RERA Practitioners Association and Study Circle Committee welcomes all of you. Webinar will be started shortly. We request all the participants to kindly mute your audio and video during the session. You all will be allowed to ask questions at the end of session.
Hello, Smita ma'am.
Welcome, sir. Sir, we are not able to hear you.
We can.
Shantanu, sir.
Am I now audible?
Yeah, you're audible, sir. Yeah, we can hear you.
Yeah.
I was not getting unmute. Sorry, something went wrong with the laptop. It got booted again.
So no problem, sir.
Okay.
Yeah, please start, sir.
Please.
Okay. Thank you. Good afternoon. Rather, it is good morning. Still, we are in the morning session. So, very warm welcome to all of you. And I really appreciate the efforts being taken by RERA Practitioners Association for giving various information to all the colleagues as well as to the public at large. I'm really appreciating this particular thing. Today, I have been asked to say something on housing societies chapter, which has been introduced in Maharashtra Co-operative Societies Act 1960 recently, that is about last year. Friends, let us try to understand what are the aspects of this particular matter. The Co-operative Act, when it came into the field in the year 1960, the provisions therein were made possible with reference to all the cooperative societies and all types of cooperative societies, including housing, were covered by the said provisions. And the provisions were so nicely made that each type of cooperative society would be covered in it. The provisions related to each type of society were sought to be incorporated in the respective bylaws of those societies. And then Co-operative Act read with the rules, read with the respective bylaws of that particular type of society,
check,
formed
check,
the
check.
governance rule or governance aspect with reference to that particular type of society. However, as the times lapsed, the society's number in the state of Maharashtra increased to a greater extent. It is more than 2 lakhs, all types of societies. But the number of cooperative housing societies increased too much. And it is almost 50% of the present strength of the cooperative societies in the state of Maharashtra. So almost 1 lakh plus are the cooperative housing societies. And therefore, obviously, the people or the members of these cooperative housing societies felt that they should have clarity on their subject with reference to their type of societies. And therefore, there was a demand for having a separate chapter on housing. And then the legislature thought it proper and introduced the bill for the amendment and introduction of the housing chapter for the first time in the year 2018. In fact, the ordinance was promulgated in the year 2018, and that is on 30th October 2018. And then again it was introduced, the said ordinance was introduced to the Legislative Assembly on 22nd November 2018. However, the said ordinance could not get converted into an enactment, and the bill remained as it is. Therefore, a need was felt to again promulgate new ordinance, and accordingly in March 2019, an ordinance was issued incorporating Chapter 13B in the Maharashtra Co-operative Societies Act 1960, thereby incorporating the chapter especially and specifically for housing societies, governance of housing societies. That ordinance has now, to my knowledge, been converted into a law on or from 23rd July 2019. I would like to start with sharing of my screen. Just a moment. I would request for a moment. Please bear with me for a moment. I'm opening my PowerPoint presentation so that we can see the things properly. In the meanwhile, I would continue to speak, and it would not be out of place to mention that this particular chapter, which has been introduced as 13B in this Maharashtra Cooperative Societies Act 1960, it specifically deals with the provisions which would govern the societies which are housing societies. Now, from my last lecture, I think everybody must have understood the type of cooperative housing societies in this particular Maharashtra Cooperative Act. There are basically two types of cooperative housing societies. One is tenant ownership, another one is tenant co-partnership. A moment, please. Hello. Hello, am I audible?
Yes, sir. We can hear you, sir.
My video has gone off. I don't know what went wrong.
Yeah, but we are able to see you, sir.
Okay, I'm not in a position to see myself. Okay,
So just
that's
check
fine.
the option below that stop video and start video.
I would just okay. It doesn't matter for me. Now I'm sharing my screen over here. Is the screen visible now?
It has not yet appeared. It's saying that you have started sharing,
Yeah.
but we are not yet able to see it over here. Yeah, it's visible now, sir.
Okay,
Okay.
fine. So this was the basic statement while introduction of this particular enactment in 2019 or the amendment in 2019. Now, what kind of amendments are made in this particular chapter? That will have to be seen first. See, while the separate chapter for the housing was introduced, the certain provisions of Maharashtra Co-operative Societies Act were made applicable to the housing and certain provisions were not made applicable. Section 154B of the Maharashtra Cooperative Housing Societies Act, now introduced, it deals with which of the provisions of the act are made applicable and which are not. I'm not going into the details of those provisions at the moment because that would cover too much of time for us. Then it is very much important for us to understand that in 154B, the definitions of Maharashtra cooperatives of various types of definitions are introduced for the first time, I would say, which were never there in Maharashtra Cooperative Societies Act. The first of such definition is of builder promoter, allottee, and then builder promoter, allottee, then associate member, architect, association of societies, then also corpus fund, cooperative housing association, dues, flat, member, and the types of in the types of members, associate member, joint member, provisional member. These are the basic definitions incorporated. One more definition is incorporated is proposed society. Because previously it was just understood what do we mean by proposed society, but now the definition has also been incorporated. I would like to deal with certain provisions and I would like to show you only some provisions therein which deal with this particular thing. One of such provision is corpus fund. See, we know these days the housing societies are formed by virtue of the construction on a plot or major land by erecting multiple buildings of multi-storied buildings, and that these buildings then either get themselves converted into a cooperative housing society or a complex is converted into a cooperative housing society as a REIT. The builder having recovered certain funds from the purchasers of the flats, he has to transfer certain reserved funds for the maintenance of the society and all other things, and which forms a corpus fund. Now, for the corpus fund, fund means payment received or receivable by the society from the developer in lieu of surrendering purpose to mention here. Though the word developer is used in this particular definition, there is no definition of a developer given in the Maharashtra Cooperative Societies Act as yet. To my knowledge, this particular definition doesn't appear even in the RERA or in the MOFA or in the MOA. Now, therefore, the question is, we have to understand what it, but however, the definition of builder promoter is given in this particular enactment. I may mention at this juncture that the definition of a build flat or builder promoter or promoter, whatever we call it, as given in this particular chapter under section 154B1 is much more wider than those covered in MOFA. There is no, therefore, in my opinion, there would not be any need for importing any meaning thereof from other enactments. Then associate member definition has been given in this particular enactment newly. It is not that it wasn't there earlier. The earlier also the definition of associate member was there. Now for the purposes of housing society, the definition of associate member has been little bit modified. Time, but let me mention that these definitions which I have just now reproduced or uttered would have definite meaning thereof and would mean a lot in understanding the chapter and reading the provisions thereof. One important definition which I would like to mention here is that of a provisional member. The provisional member, which has been defined as like is, means a person who is duly admitted as a member of a society temporarily after death of a member on the basis of nomination till the admission of legal heir or heirs as member of the society in place of the deceased member. This is the definition of a provisional member. Earlier, joint member was not there in the Cooperative Act. Now the joint members definition is given because many a times it so happened that the persons purchase the property in the joint name. Basically, normally the husband and wife purchase the property in their joint name, or sometimes son and father, or likewise. And then the fact that they were not considered as a joint member, but one whose name appeared first in the share certificate would be a member and the other would be associate member. But now by incorporating the definition of a joint member, the purpose would be much more different, because joint member recognizes the rights of the members who are holding the property jointly, and they would be holding share, right, title and interest in the flat or the property in the society jointly. And however, his name would not stand first in the share certificate. That is, this person would be called as a joint member. In respect of an associate member, his name would never appear on the share certificate, and it would be mentioned only at the back that he is an associate member. That's all. Now, the next part which I would like to cover is Section 154B2 and Section 154B3, they deal with the provisions regarding the registration of a cooperative housing society. I am sure you would not like me to reiterate the same, because few days back I had discussed this particular aspect in details with all of you, and I had shared my views on the registration of the. I may mention here at this juncture that there are two types of societies which are contemplated and which have been taken cognizance of, and one is tenant ownership cooperative housing society, another one is tenant co-partnership housing society. The other housing societies are also covered in this particular section, that is to say house mortgage societies, premises housing societies, etc. And basically these types of societies that do exist, the number of such societies is very less. But what is appearing today is the scenario is the tenant co-partnership housing societies are much more in number, and tenant ownership housing societies are little less in number. However, the provisions of section 154B2 deals with the registration part. Section 154B3 deals with the opening of the name reservation and opening of the bank account of this particular society, which would be proposed society. Section 154B5, I would be directly dealing with section 154B5. This puts restrictions on admitting members to the extent of number of plots or flats in the society. Previously, there were no statutory provision like this. The bylaws would mention it remotely that such should be the situation. But many a times it so happened that the waiting lists would be there, the persons would be admitted, more than one person would be admitted to the membership without there being any properties to be allotted to him. But now the situation is different. Section 154B5, it deals with the provision which speaks about restrictions on admitting members to the extent of number of plots or flats. It depends upon the type of society which that society is. Voting rights, so far as regards voting rights are concerned, those are governed by the new provisions. Now, voting rights, Section 27 of the Maharashtra Co-operative Societies Act also deals with the voting rights of the members of the society, including those who are associate members. Now the provision makes it clear as to a member of the society shall have only one vote, and that too to be exercised personally. Associate member shall have right to vote with the prior written consent of the member. But if the associate member exercises the right of voting, obviously the member would not get that particular right. Joint member is also having right of member with the permission of the person whose name stands first in the share certificate, and in his absence, the second one, in the absence of first two, the third one, and likewise the voting has to be exercised. One interesting part is that even the provisional member has been given the right to vote. We have seen just now the definition of a provisional member. The provisional member would get a right to vote in the society. Obviously, he would have one vote in the society. So this is how the rights of voting or voting rights aspect. Then Section 154B12 and 154B13, they deal with the transfer of rights of members to transfer their share, right, title, and interest in the society. Previously, right of transfer of share was only concerned with the society, especially in the tenant ownership society. And with reference to the plots or the flats, it was being considered like this, that the person who is having any plot or flat in the society, once his shares are transferred to the other person, there may be or may not be a document of transfer of the property, that is flat or plot, in the name of the transferee. But that concept has gone. There were confusions with reference to this type of provisions, and therefore now the clear provision has been made in section 154b12, which says that the right of a member in the shares, right, title, and interest in the property of the society could be transferred only by a registered document, and that too in accordance with the provisions of the Act, rules, and the bylaws. The bylaws would also would be taken into consideration for the purposes of such transfer. So this is how the general provision with reference to this particular transfer. Now, with reference to section 154b30, it deals with the rights to transfer on the death of a member. I would like to remind you that section 30 of the Maharashtra Co-operative Societies Act also deals with the right of a person or to transfer the rights with reference to the shares and the right in the property of a person who is dead or deceased. All his rights shall be transferred to the member, incoming person, in pursuance of section 30. But now that provision has been incorporated in section 154b13 with reference to the housing societies specifically. And it says the same could be done on the basis of a testamentary document if it is, or on a succession certificate, or legal heirship certificate, or document of a family arrangement, or to a person duly nominated in accordance with the rules. However, I may remind here, there was a dispute with reference to the tenant ownership society, where the plot belongs to the society and the superstructure used to belongs to the member concerned. In a Ghatnekar versus Ghatnekar case reported, the aspect was taken cognizance of by the Lordships of Mumbai High Court, and it was so decided that with reference to the right of a deceased person in the shares and the property of the society, the shares were considered as the property of the society, and another part of the property would be the leasehold rights or the plot in the society. And those rights could be transferred from the deceased member on the basis of the nomination, and that was the decision in Ghatnekar versus Ghatnekar. However, so far as the superstructure is concerned, the nomination would never prevail. That was the decision. Here, the section provides that the society shall admit a nominee as a provisional member till legal heir or heirs or a person who is entitled to flat and shares in accordance with the succession law or under will or testamentary document are admitted as a member. If no person is so nominated, society shall admit such person as provisional member as may appear to the committee to be the heir or legal representative of the deceased member in the manner as may be prescribed. And this right has been given to the society or the managing committee of the society. Obviously, when we talk of society, it is the committee of the society, because all the membership applications are to be considered only in the managing committee of the society and not otherwise. Therefore, this provision makes it amply clear as to how the transfer of shares and interest in the property of the society would get transferred from the deceased person to his legal heir or nominee or otherwise. Then the managing committee, section 154B19 provides for the managing committee and the strength of the managing committee as may be laid down by the government. That is what it says. I'm not reading the provision as a whole because I have not reproduced here the provision. See, these normally the strength of a managing committee would be 11 to the maximum extent normally, but it could be more than that also, depending upon the nature of the society. If there are more buildings in a housing society, housing complex, I would say, and there would be need for more persons to be incorporated in the managing committee, then that could be considered by virtue of the provisions in its bylaws by the society concerned, with the permission obviously of the registrar. Now the question would be how the managing committee gets into the seat or how it assumes the power. So obviously by election. Now election of a housing society has been divided into two parts. See, you people may be aware that section 73CB has been introduced in the Maharashtra Co-operative Societies Act 1960 in the year 2013 by virtue of the amendments therein. At that time, this particular section provides for the formation and creation of an authority which is called State Cooperative Election Authority. This State Cooperative Election Authority has been given total right or authority to conduct the elections of all types of cooperative societies in the state of Maharashtra, except those which were taken out of their purview. And then the question had arisen with reference to the housing societies. If the housing societies election is also to be taken under the supervision and control of the State Cooperative Election Authority, then the delay always occurred, and the question of the validity of the committee which is existing or whose period is going to come to an end would ever arise. And therefore that particular difficulty was definitely arising. And to resolve this particular difficulty, firstly, the provision was made that there should be no elections at the hands of SCEA, that is State Cooperative Election Authority, whose membership is less than 200 or less than 200. But now that figure has been increased, and that is 250 or less. No elections would be held by the State Cooperative Election Authority, but by the society itself. The society has to hold the election of such societies. Where the number of members are more than 250, then the State Cooperative Election Authority has to hold elections under the provisions of section 73CB. Provision has also been made in this particular section for reservation of certain seats. One seat each for scheduled caste, scheduled tribe, one category, OBC, another category, VJNT or special BC, third category. So three seats are to be reserved for these three categories. And in addition to this, 2 seats for women are to be reserved on the committee of housing society that has been made mandatory. But it has been so provided that in case these seats do not get filled in for any reason whatsoever, then the such number of vacancies would not be considered for the purposes of taking into consideration the quorum for the meeting, and that number would be lessened, and then the remaining committee would be taken, that number would be taken into consideration for the purposes of deciding what quorum it should be. And normally the quorum is 50% minimum, 50%. In certain cases, the quorum is required to be more than 2/3. So that is a different aspect. I would not deal with those aspects, but this is what the provision is made in section 154B19. No confidence motion. The provisions of section 73 ID are already there in the array. All types of societies are covered under section 73 ID. However, the legislature thought it necessary and proper to have separate provision for the purposes of no confidence motion on the officers of the society. And therefore, section 154B24 has been introduced, which says, except subsection 1, the provisions of subsection 2 to 7 of section 73 ID shall apply mutatis mutandis to the action of no confidence motion on the officers of the society as defined in that particular section itself. And therefore, this is what the provision is given. What is important now from my point of view is allotment of plots, flats, or houses through draw of lots. Previously, there wasn't any such provision. The bylaws used to have such a type of provision regarding allotment, but there was no uniformity in even the bylaws or adoption of the bylaws or making provisions in the bylaws, though the standard model bylaws were prescribed by the government. Many a times those bylaws were modified by the societies to suit their particular convenience, and registrars didn't bother so much because of this particular thing. Many times in the societies which are tenant co-partnership societies, the situation had always arisen that the builder has sold a flat along with some common area, such like say parking space or some other things in the society, even some common terraces or part of a terrace to the concerned person. And then the question would always arise as to whether such allotment or such a sale would be proper or not. Already there are decisions on this particular aspect by even Supreme Court, and therefore I would not be dealing with those particular aspects. But now the legislature thought it necessary to make specific provision by virtue of the provision incorporation of a provision of section 154B26, and it subsection 1 says, except under a contract to the contrary, allotment of plots of land, flats, house, or other dwelling units shall be made by the committee strictly on the basis of draw of lots to such members whose enrollment as a member is found proper in accordance with this act and rules and the bylaws. I may pause for a moment here. When we talk of except under a contract to the contrary, say if I have entered into an agreement for purchase of a particular flat with the builder, and then after that the society is formed. The question would arise, why should I get some other flat and not the concerned flat which I have agreed to purchase? And therefore, I want that the allotment of the concerned flat only should be given to me and not any other flat, or even including the plot also. When I have selected a plot and it has been agreed that I shall get that particular plot, then I should get that plot only in an allotment. That is how this particular provision covers the aspect. Obviously, when we talk of number of plots and number of members, then the question would ever arise when the saturation has reached. That is, if the number of members and the number of plots or the flats in the society are equal, the transfer of flat or the plot, as the case may be, and therefore the allotment of such plot or flat would take place only in accordance with the provisions earlier mentioned, that is by way of a transfer of share, right, title and interest in the property, including the shares of the society. And therefore, by virtue of a document that would go to the new incoming person, and the society will have to give a consent for the purpose for this particular thing. Now, mere allotment in the meeting of the society is not enough. A burden has been cast on the society to issue certificate of allotment under its seal and signature in such form as would be given or provided for, and on such terms and on such conditions as may be prescribed forthwith. When all the dues are paid, this is very important. Such allotment letter would be issued only to those persons who have cleared off all the dues of the society. The definition of dues of the society has been already given in this particular enactment, and I may reproduce here for our purpose. Section 154B112, it defines dues, and that means the amount payable by a member or a flat owner to the society and demanded by the society by issuing bill or notice in writing, and such demand is based on the provisions of this act, rules and bylaws of the society. So all types of demands, including the maintenance charges, etc., would be covered, and that dues of such type also will have to be cleared before anybody claims the right to have the allotment letter. Now, you all may be aware, with reference to the recovery of the dues in a housing society, it becomes very difficult nowadays. Though Section 91 provides for a remedy by approaching the cooperative court concerned against the member concerned for the recovery. Similarly, the provision under Section 101 was also made by incorporating the dues of a cooperative housing society in the provisions of Section 101. However, when the legislature thought it proper to have a separate chapter on housing, then it was considered that even that provision also should be incorporated in this chapter, and therefore Section 101 has been amended, thereby deleting or taking out the provisions of cooperative housing society to have their recoveries obtained under Section 101. And that particular provision now has been incorporated in section 154B29. And that now section 154B29, just a moment, 154B29, I'm just reading the provision as a whole. It is a little bit more wider provision. I have narrated certain parts of this particular thing, and it says, first of all, the section 101, it has been removed from the provisions of section 10, or from the ambit of section 101, and now it has been incorporated in this particular section. The dues which are to be recovered would cover the repairs and maintenance, construction cost, service charges on the basis of statement of accounts. So the similar provisions as that of section 101 are incorporated in this particular section, but in this particular format, and any other document as may be prescribed in respect of the arrears. So there could be written agreements, written notes, written admissions, written communications, whereby two parties, that is society and the member concerned, have agreed to pay certain things, etc. The resolutions of the society charging certain amount for certain purpose, and those are not paid and are due, those would also get covered in this particular respect. The application could be made by the society now under section 154B29 to the registrar again, who, after giving opportunity to the other side, that is against whom the certificate has been claimed, would issue a certificate for the recovery of the amount stated therein to be due as arrears of land revenue. The registrar has also been given power under this particular section itself, that if the society takes or fails to take action against the person concerned for recovery of its dues, the registrar himself shall proceed to recover such amount or issue certificate against such person, and then that certificate also shall be deemed to have been issued on an application made by the society for the purpose. It has been made clear. See, I may here remind you all, the provisions of section 101, as they were applicable to the various types of societies, including the housing society, for the purposes of making application for a recovery of dues on the basis of a certificate to be obtained and granted by the registrar under section 101. All those provisions have been incorporated in this particular chapter under section 154B29. And this also further provides that the certificate granted by the registrar under either under subsection 1 or subsection 2 of the Act, this section, shall be final and conclusive proof of the arrears stated to be due therein, and the same shall be recoverable as arrears of land revenue. Further, the provision also makes further aspect and takes cognizance of further aspect that on such a certificate having been issued by the registrar, the recovery has to be made either through the recovery officer or through the collector or the officer appointed by the collector, in the same manners as for the procedure, by way of a procedure which is prescribed for the purposes of recovery of arrears of land revenue. But while doing so, the collector or other authority appointed by him shall obviously give further opportunity to the person concerned against whom the certificate is issued as to whether he pays off or not. there won't be a challenge to this particular certificate before the such authority. But only thing, whether he has paid, if yes, what remains, whether society admits, etc., etc. Though that types of inquiries could be made, and further orders would be passed by such authority. Now, here I would come to almost to the end of this particular chapter, and that is by way of a section 154B30. A provision has been made to take into consideration the winding up proceedings of certain types of societies, housing society. Especially, what is provided is house building society when have achieved their objectives. How the same is to be. In a house building society where all plots have been allotted to its members and basic civic services have been transferred to the local civic bodies. There are many societies, tenant ownership societies, which have allotted their plots to their respective members. The members have constructed their respective bungalows or buildings on such plots allotted to them. All are residing happily. The common areas such as roads, water line, drainage line, electricity lights on the street, in the common areas, all are transferred to the civic bodies, say for example, Pune Municipal Corporation or PCMC, or to other local bodies in which that particular society is situated. Then what remains? The society is not to maintain anything for the purposes of common, all those common properties are concerned. Each one is maintaining his own plot and his own building. Then the purpose of the society to remain as it is may get frustrated and may not be valid one. And then in those circumstances, it would always be proper to dissolve such type of society or undertake a winding up proceeding. We have seen many a times in such types of societies, the dispute ever arise with reference to the transfer of the rights, shares, and right, title, and interest in the property of the society in favor of another person. And then the members of the managing committee would be very stubborn, allowing such transfer, or they may allow such transfer by demanding huge amounts by, and then disputes would arise and then whatnot, and the things would go on like that. This could be avoided by virtue of this particular type of provision, because earlier when the provisions were incorporated in section 102 regarding the winding up of the proceedings, etc., those things now do not remain in with reference to the housing societies. The housing societies are now being provided under section 154B30 for the winding up of these types of societies. However, a problem was also thought over by the registrar, by the legislators, that in case certain properties are given out by the society to the civic bodies, but certain common areas like garden, play area, or some clubhouse or something like that is there, and that is being maintained by the society, and the society wants to maintain it, which is a common property of the society, and the society do not want to give away the rights with reference to those properties, then the winding up of such society would not take place unless the society decides that that has to be given out. If the society says no, we don't want to give our right to anybody else, but we ourselves would maintain for the benefit of the members and their families and all other persons, then the question of winding up would never arise. The society can't get wound up. And this is specifically provided under section 154B30. These are the provisions which I think were necessary for us to take into cognizance. And therefore, I have given presentation with reference to these important provisions which according to me are essential and were necessary to have a consideration by us. Now I welcome you all to have any question. If you have, I would try to answer your questions, and I would try to give you elaborate certain things by looking to the provisions, whatever they are. Nilesh, you may
Yes, sir.
do the needful.
Yes, sir. I request Advocate Smita Tanna ma'am to please take over the
May
questions.
I stop sharing this particular screen?
Yeah, sir. Yeah, yeah. Please.
I would do that.
So you will be visible to all of us then.
So yeah, I have a problem. I am myself, I'm not able to see myself.
So
just
I don't know what is wrong with me.
sir, just stop your video and again restart.
video,
Okay.
video. Yeah.
And again, I would restart.
Yeah.
Nothing is happening. Okay. You people are, I hope you are able to see me.
Sir, just a minute. No, we are not able to see you. That's why I will just do some settings. Just a minute. Please mute yourselves. Sir, now you please start your video.
I have clicked on the start my video.
Okay.
Again, I am receiving a message that host has stopped your video.
No, sir.
Yes,
It
same
is on.
message is
Just a
same.
minute, sir. Spotlight your video. Let us see. निलेश सर तुम्ही काय करताय का मग मी थांबते
Sir,
हा you start. I will not
no.
touch the settings. Yeah,
No,
please.
Khurjekar
Spotlight his
sir.
video.
Okay. Khurjekar sir, पुन्हा एकदा ट्राय करा बरं व्हिडिओ स्टार्ट करायचा.
मी आधी स्टॉप करतो आणि पुन्हा
चालेल सर, चालेल.
स्टार्ट करतो. I would try to find out what are the video settings.
Host has stopped the video.
So here we can see कि it is. एक मिनिट सर तिथून स्टार्ट करा बरं.
मी केलं. मी पुन्हा रिक्वेस्ट पाठवली व्हिडिओ स्टार्ट करायची.
ओके. बट ही इज को होस्ट सो ही कॅन ना.
या ही कॅन.
नाही ते त्यांचा लॅपटॉप वरून नाही ना आता कुठल्या दुसऱ्या ह्याच्यावरून आहेत. एक
नाही
मिनिट.
लॅपटॉप वरतीच आहे मी.
हो का.
हो. Okay, and I am receiving a request for start my video and I have clicked that. Okay.
No, but we want to see you, sir. Something we need to do. Sir, just log in and log in again, sir. Log out and log in again.
Shall I do that?
Yeah, please.
It would take some few.
No problem. No problem.
Okay, I would do that. I'm leaving for a moment.
Yeah. Participants, please bear with us. Sir will join us soon, so that we can have question answer session properly. Now chat box is open. So if anyone has query, you can type it in the chat box. Just a minute. So if anyone has queries, you can type it in the chat box or raise your hand so that we will allow you to speak one by one. Till then, please mute yourself.
I unmuted myself.
Just a minute, huh, sir. I'll just see.
Still, I am not.
Just a minute, sir.
Yeah, okay. Please go ahead.
I am not able to see you.
I have started my video. I have also unmuted myself.
Okay. Just a minute, sir. Let me check. Manasi Khurjekar, no?
Yeah. Sometimes it is showing as Manasi Khurjekar, sometimes it is showing as
Okay, okay, okay. But why we are not able to? Just a minute, sir. Sir, whether that what we say selfie mode and the backside mode, just touch that first.
Where do I get that?
And that is on the camera itself, in front only.
Ma'am, I think you should click the view video setting. Sir, you can see that mute and stop video icons on the left side of your screen. So you please click that video setting or see the camera. It has been clicked or not.
Here it is video settings.
Yeah.
Yeah, in the video settings, what should I do?
After you clicking that video setting, are you able to see yourself over there?
No.
So then see that, click that camera option. Yeah.
There isn't any camera option. There is camera, yeah. Laptop integrated webcam, it shows me.
So that you have to select.
16.9 widescreen.
And the original ratio. So please click that. Please click that arrow shown in that box in front of that camera.
It shows a laptop integrated webcam.
Only one option you can see.
Yeah.
Is that clicked?
I clicked it. Now it is showing laptop integrated webcam.
You are able to see yourself in that screen?
No, sir.
Oh, what has happened?
Okay, I think.
Sir, what about from your mobile?
Yeah,
I would try.
Let this laptop be as it is, and again, sir, try joining from mobile as well.
Okay, I would do that.
Yeah, in Facebook also it is blank. Nilesh sir.
Yeah.
Share that gallery view. No?
Yeah. I have already shared that gallery view, ma'am.
But in Facebook.
Now, am I able? Am I?
Sir. Yes.
From
wait
my
a minute,
mobile,
sir.
I'm able to see.
Yes, sir. Thank you, sir.
Okay.
Now we will have that speaker view so that whoever asks question, you will be able to. Yes. So I'll read the questions. Just
okay.
So many questions, sir. Okay.
You ask one by one.
Yeah, I will ask. I think one, Mr. Nitin. Yeah, one question from Advocate Nitin Munoth. ULC Act and MCS Act, various promoters have used or using the MCS Act to come out of the Duchess of the ULC Act, how it works.
How
It works.
how it works?
Yeah.
No, see, when the ULC Act was there in the array, and at that particular time, the provisions were there made under the ULC Act itself, that if the property which is undergoing the ULC reservations,
Okay.
then those
uh, provision
provisions
could be considered and the property could be
property could be taken out of the clutches of the ULC Act.
okay,
Okay.
and therefore the provision would be uh,
Governed by those provisions,
and the cooperative society it is to be formed.
then and then only the exemption was given to such properties under ULC Act. Now, as ULC Act has gone, but certain terms and conditions under which the provisions were made applicable have remained as it is.
Okay, sir. The next is question from Advocate Tushar Khade. Is he there? Mr. Tushar? If you want to ask, you can unmute and ask yourself. Otherwise, I'll have to read. I think he is not there. Okay. It is asked whether heirship certificate required after death of a member of his heirs. And if no, then what's the procedure for recording heir's name on the society share certificate? Can you hear me, sir? Hello? Sir, you are muted.
Now, please repeat the question.
Okay. It is regarding the heirship certificate. It is asked whether heirship certificate is required after death of a member to his heirs. If no, what is the procedure for recording the heir's name in the society share certificate?
Heirship certificate is required because now the provision says that mere nomination would not be able to be accepted by the society.
Okay.
The nominee would be admitted as a provisional member, and if all other legal heirs, if they by a document transfer their respective rights, title and interest in favor of the nominee, then and then only the person would get the membership exclusively. If not, and if the other legal heirs claim certain rights in the property and the shares of the society, then they will have to get the same decided through proper court, either in the form of heirship certificate, or if they have a document of testamentary document such as will or some other family arrangement, etc. Then those things could be taken cognizance of by the society at that time, and therefore the question would arise in that sense, like that only. And the people cannot accept the membership as it is, and the heirs will have to prove their right through proper channel.
Sir, your video, now it is correct.
So, Shantanu sir, one request. If you're operating both the devices, you mute and stop the speaker voice of that either of the laptop or of the mobile. What is happening is we are receiving echo because of both the units are going on.
Now, what is the situation?
Now we can hear properly.
Okay.
Yeah. Tanna ma'am, please continue.
Yeah, okay. The other question is, I think somebody, Mr. Kashyap Patel, he has raised his hand. So I'll request him to ask the question. Mr. Kashyap.
Yes, thank you, ma'am. Good afternoon, sirs, and good afternoon, all colleagues. Firstly, thank for this wonderful session where we can share our views and everything. So I'll straightly come to the point, sir. There are two questions of mine. Whether the new amendment in regards to the associate member, provisional or jointly members will be effective or arguable in the court for the agreements executed in 1986 or prior to that.
Sorry, may Tanna madam,
हाँ
may,
sir.
may I log out of this particular laptop so that there would
Better,
not be,
better.
I think I would.
Okay, sir.
Uh,
And then you can fix up your mobile in front of you, sir.
yes, I would do that. I am leaving.
Please.
Ma'am, I guess sir is muted again.
Let me check. He will unmute himself. Let me see. Sir, please unmute yourself. I'm unable to unmute.
Yeah.
Now
Yeah,
yes. Okay, okay, okay.
Yes, audible.
Yes. Now
Yeah.
you continue, sir.
Yes, sir.
Yes, please ask the question.
Sir, there are two questions. One is whether the definition of associate member, jointly or provisional member, which has been amended recently, would we have would or have any effect for the agreements executed prior to 1980s or 90s? That means retrospective effect.
No. So far as regards joint members are concerned, this particular definition has been introduced recently. Okay. The question is, you are asking whether these provisions would be made retrospective. You want to ask that question. Am I right?
Correct, sir.
Yes. See, so far as regards associate or joint member, these definitions are concerned. No, see, associate members definition was always there.
Correct.
There was no question of any, it cannot be any question of confusion with reference to those prior to this amendment or otherwise. But so far as regards provisional members are concerned, they are going to be made or having been made after the amendment. The recovery would definitely, this particular action on the part of society can't be retrospective. It has to be prospective on the date when these persons are admitted as such, even including the joint member. Now, previously, even though persons were holding the property jointly, the one of such persons used to be a member and another used to be an associate member of that particular person. So their rights are governed under the definition of associate membership, though they were holding the property jointly. And there is no difficulty in recovering the property from either of the persons or from both or otherwise. In my opinion, it would depend upon what is the situation, who is holding what right, and what is the status of such person in the housing society. It would depend on such situations, but certainly these provisions cannot be made retrospective.
Okay.
Okay.
Thank you, sir. Thank you. So, and ma'am, just with your permission, can I? There's one other question.
Yes, yes.
Please.
So, where I'm referring to the retrospective effect, in the same issue, there is say open terrace adjoining to the flat allotted to one of my clients, and that is also a retrospective thing. But now, due to the redevelopment and without any documentation proof available with my client, they are not able to recognize my open terrace due to the loss of documents or not, even though I have a registered FIR, everything.
See, the difficulty is always there. See, so far as regards open terrace part is concerned, which is not a common one or exclusive, if it is included in the agreement of the concerned person for purchase of flat, then that could be considered, otherwise not. If it is by way of a letter of allotment given by the builder that you shall enjoy this particular terrace, exclusively for yourself, such a document cannot be recognized because it is not a transfer at all of any property. And that terrace, if it is not shown in the sanctioned plan as an exclusive terrace attached to the concerned flat, and it is shown as a common part of the terrace, then definitely the person cannot claim any right without there being. And even if such a common terrace is partly given to a person concerned, which is sanctioned as a common terrace, then also the right cannot be claimed because that would not give him any right for the for such terrace, according to me.
Oh, okay. Thank you so
Okay.
much, sir. Thank you.
Then,
Okay.
Sir, Jyoti Kanodia has one question.
Okay.
Jyoti, are you there? Okay, yeah. She is asking, can an associate member can participate in an election of a housing society?
Yes, with the consent of the member, written consent of the member.
Okay. Then the another question from Chandrakant Chavan. It is that if the same flat is transferred in 1 year or for more than one time, does it attract stamp duty for each time?
I have not understood the question properly.
It is said that if the flat is transferred in 1 year for more than one time, does it attract stamp duty for each time?
It should. It should, because transfer from A to B is attracted with reference to the stamp duty. Transfer from B to C again would be a transaction of sale or something like that, and that would attract the stamp duty. These are two different transactions.
True. So another question from Dr. Ruby Chadwal. This asks that can a provisional member be taken in the society committee being a woman?
There is no restriction as such under the provisions, and provisional member could be taken in the managing committee, but her provisional membership is subject to the other legal heirs getting their right through proper channel.
Okay.
So if the other legal heirs during the tenure of the such person as a committee member acquire or establish their right to the said shares and the flat, then the question would arise whether the person would continue as a member, because the moment that right of such a provisional member is gone, he can't continue to be a member of the society. That would then the question would arise with reference to that.
Okay. Then another question from Ms. Shilpa Pratap. Madam, are you there? You can ask your question. Shilpa? I think she is away. Okay. Then again, a question from Advocate D.N. Nair. Sir, are you there? You can ask the question. Unmute yourself and ask the question. Okay. The question is, as regards joint membership, in case of a membership being obtained through legal heirship certificate, can both the legal heirs claim joint membership and can make individual nomination for their heirs in the event of dispute between the two siblings whose right will prevail?
See, so far as regards joint members are concerned, one aspect will have to be taken into cognizance, and that is to say, A and B are joint members. By what means they become joint member is, according to me, irrelevant for a moment. For a moment, I would say.
Oh.
Now, both are entitled to have their nomination made in the society, and that could be recorded. But before they are admitted to the membership, they will have to give a declaration as whose name would stand first and whose name would stand second and third, and etc. That has to be made declaration, and accordingly the society would admit their names in the record of the society, one, say A, B, C, like that. Or if B says, no, my name should be first, then BAC or BCA, whatever it is. Okay. The question is, so far as regards the legal recognition of this person is concerned, if the person dies, then in his place, his nominee would be admitted as a provisional member, considering if the person concerned, deceased person concerned, had some other legal heirs, then their rights would be decided in accordance with the law, with their amenable, and then the right of a person as a nominee of the person concerned would be considered whether it is valid or not. So therefore, the provision is made of a provisional member, not admission as a whole or member in exclusion of other legal heirs.
Okay.
So therefore, the if you the question is A and B both have made nominations and A dies, then would the nominee of a B would succeed, or if likewise? That appears to be the question, or whether B would become the first person and then the legal heir of A would be admitted secondly. No, it won't happen like that.
Okay.
Hello,
Hello.
I hope
can I
I
ask
made
one
myself.
question?
Yes, madam.
Yeah,
Please.
please.
Yes. Sir, how to make a conveyance in favor of society if there are more than 5 buildings and 5 separate societies and the apex body has been formed? How to make a conveyance of common amenities and the superstructure considering the RERA provisions?
How to make the association of societies?
No, sir,
Or
conveyance of the
the
society.
correct
Sorry,
association of society or federation of the society will have to be formed, and the conveyance will have to be made in such association or in favor of such federation.
okay, sir. What about common amenities and facilities? It will be in means सगळ्यांना इक्वली त्याच्यात जाईल की कसं होईल?
It depends upon the area. See, each building, if they are of the same size with the similar amenities, then there will be equal distribution. There could be, I'm not saying would be, there could be equal distribution of the common amenities and common areas in the entire campus. But if the society, I mean, the buildings are having different areas and different flats, number of flats, then according to the calculations, there could be different situations and different reservations or different interest of each building over the common property or common areas. And the property has to go like that only.
Okay, thank you.
Can I disturb?
Yeah, please.
See, under now the RERA, there is a rule number 9, which describes how to give conveyance to the, in case of society, promoter to convey title under section 17 of the Act, provided for conveying the title promoted to the allotee in case of plots. This is one period of conveyance of title for promoter. Here it is in rule number 9, read with section 17 of the Act.
Exchange password required.
Hello.
It says the structure should be given to the respective society found by those members, and in case of land and a ground floor and staircase, that should be given, conveyance should be given to the housing federation, federal societies.
Correct.
So
See,
that rule 17, section 17 and rule 9 is to be read as per the
You're
RERA.
right. You're right, and that is a correct provision. Please kindly consider one aspect. See, it is like a tenant ownership society. There are several plots and several buildings are constructed on these particular respective plots. See, the society has to be formed of all the plots. The society would be there for all plots and the maintenance of the plots and the common areas in the plot in the society. superstructure would remain the ownership of the concerned member. Similarly, here in the federal society, all other societies are its members.
Correct.
So the superstructure, that is the building concerned, would be owned by the respective society, and the land would be owned by the federation or federal society.
Yes.
So that has to be like that only. Anything?
May I ask question, please?
Please.
Yes, please.
First of all, I would like to thank you, sir, and the team who has taken efforts to arrange this webinar. And good afternoon to all. Myself is Advocate Vaibhav from Pune. Sir, I would like to question with regards to section 154B13.
30 or
13.
Okay.
Yeah. This is with respect to right to transfer on death of member.
Correct.
Right. Sir, if a member dies, then in that case, nominee would be the provisional member of that society.
Correct.
But now my question is, before getting any kind of directions or order from the concerned authority or court, during that period, whether that provisional member can cast his or her vote, and if yes, then who has from whom he has to take or she has to take permission?
No. See, one aspect you kindly consider, section 153.13. It's that the right shall be transferred the deceased person to the legal heir on the basis of the testamentary document or succession certificate or legal heirship, etc., etc.
Right.
If nothing is there, then the nominee has to be admitted.
Okay.
See,
I'm not able to hear you, sir.
The concerned membership cannot remain vacant or void.
Okay.
During the period till which the membership is established or the right is established by the legal heirs through proper channel. Okay. So somebody has to be responsible for such property. And therefore, if there is a nomination by the deceased person, the nominee would get the membership as a provisional member subject to his rights being governed by the provisions of section 154B3 or 13.
Okay.
I would like to here earlier section 30 used to say that the nominee would, if there is a nomination, it would exclude the rights of other legal heirs, and it would be the person would be admitted as a full-fledged member in place of the deceased member. That was the provision, or that was the interpretation of that particular provision previously. But now that anomaly has gone.
Okay.
Okay.
Okay, sir. Yeah. Thank you very much, sir.
Sir, I would like to ask one question.
Please.
Hello.
Yes. One by one, please.
Hello. Sir,
Yeah.
can I ask one question?
Madam, please rename yourself.
Sir, Advocate Tamanna here, ma'am.
Okay, please ask.
Yeah, I just want to ask, sir, if the member of the society is facing any parking issue, if the member has already given letters and all this correspondence with the society by saying they are facing a parking issue, so in that case, whether a society can itself allow alternate parking, or he can exchange with any other member of the society?
First, my question to this one would be whether the person was allotted or member was allotted a parking or parking area, whatever you called it.
Yes, sir.
It was allotted by whom?
Society.
By the society, it was allotted. And then what? Then something went wrong and parking is not available.
Parking was available, but then there is sort of place because the member is facing some issues.
The parking lot is
The
small.
car is getting damaged actually. People are throwing, like something or some or the other things. So because of that, the car is getting damaged. So we have already requested the society to give to allot us alternate parking. But then in that case, society is saying, okay, we cannot allot parking, alternate parking.
The plot is small.
If the alternate parking is not available and if the society is unable to allot something, then the issue.
Sir, I just want to ask whether the member of the society, can exchange parking with the same member of the society with other member of the society, if the society gives consent.
Yeah, with the consent of the society, it could be.
With the consent of the society, it could be.
Yeah.
Okay, sir. Thank you.
Okay.
Hello.
Who else? Yeah,
Yes.
please ask.
I am Kandekar. Hello, sir.
Bola.
Hello.
Bola,
Sahib,
bola.
lecture खूप छान. You have enlightened us on this aspect of the. Hello.
Yes.
Hello.
Yes.
Thank you very much. You have thrown light on this crucial aspect of the this thing, RERA Act. My question to you is that now we have been housed in one newly constructed building. Builder had assured us to form society and get it conveyed. He has not done yet. He has not conveyed the property and not formed the society. Now he has read certain bill. For example, till December he had to give us the society to be registered, and now he is asking maintenance from December to March. My question is, can a builder ask for the maintenance if he has failed to form and hand over the society to the person, to the members, and what would be the recourse? Please, sir, enlighten.
Excuse me, but this is a personal question which I would be answering not to its fullest extent. I won't be able to answer, but I am answering it in this particular manner that
please, sir,
if you have not got the society registered, now by virtue of the provisions of RERA as well as the MOFA, you have to approach the registrar for getting your society registered under the pretext that the builder is not cooperative. Okay. The society will be registered, and after the registration of the society, if there are completion, etc., then within 3 months the conveyance has to be made. You also can approach the registrar thereafter within specified time for getting the property conveyed in the form of a deemed conveyance. So these aspects are always there. Now, whether the builder can ask for the certain amount, then go through your agreements and consider all those aspects, because it would be difficult to answer this question in vague without looking to the provisions of your agreements, respective agreements. Okay. But these are several aspects which I would be placing before you so that you can consider the aspect.
Correct. If required, I will contact you, sir. Please.
Please, you are welcome at any time.
Yes, sir. Thank you very much, sir.
Can I ask a question?
Please.
Can I ask a question?
Please.
Madam? Yeah.
Yes.
My
please,
question is, if there is a cooperative housing society where the bylaws provide for one member, one plot, can those bylaws be amended and any plot be given to a builder developer for development and sell to many owners? Initially, the bylaws provide that only one member, one plot. But now, can the bylaws be amended and you create, you give it to a developer and a multi-owner society or association of apartment owners? Can that be done? Can that be converted into
nowadays this is the very common and common problem. Hello.
Yes, sir, you are audible.
Okay. Nowadays, this is a very common problem.
Structure.
Hello, I'm trying to answer.
Yes, please, sir.
Yeah. Nowadays, this is a very common problem, and previously, the by
Yes,
virtue of
sir.
the
Yes, sir, we can hear.
by virtue of the Karvenagar judgment, the society could not have
Oh, I think
converted
the
the
audio has
property,
gone
converted
again.
that particular society, and no society within society could be registered or accepted. That was the concept. But now that has gone. That concept is already gone. Now, in a plot holder society, see, many a times it so happens that I become a member for the particular plot and I want to construct a house. But by virtue of so many difficulties, I may not be in a position to construct a house for myself. So what I do, with the permission of the society, I would I would rather construct a multi-storied building, sell out some of the flats and retain 1 or 2 flats for myself, and I would stay there. If the society permits, and if the particular construction is comprising of, now by virtue of the new provisions, 5 or more apartments are being made, then the society of that particular apartment or that particular building could be registered. But if it is not so, then the apartment deeds or deed of declaration under the Maharashtra Apartment Ownership Act could be executed and done. But the person who would remain member for the concerned plot would be one person, and the others would become either associate members or joint members, as the case may be. But there would be one member, and it is not, see, joint members are taken into consideration, joint or associate members together with the member are taken into consideration of one member. It is not that there are many members. The other persons cannot be admitted to the membership of the society, as the flats constructed on such a plot is not the property of the society. Kindly consider this aspect. I hope I have made myself clear. Hello.
Hello.
I'm unable to answer here.
Hello.
Amended, right, sir?
Sorry,
Would the bylaws need amendment in such case to allow this?
No, in this respect, there is
Would the bylaws need amendment in such cases?
No, I don't think so, because the society's classification remains, or subclassification remains as a tenant ownership society.
Thank you, sir.
Yes.
Sir, now time is running short, so remaining questions we will forward it to you, sir, and then your answers will be placed in RERA group. I request participants to join the RERA group. A link is pasted in the chat box, please.
Can I ask the last question? I raised the hand.
Yes, Mr. Nilesh, please.
Yeah, my question is faced by all the societies. See, even if there is a provision of section 91 or earlier 101 or now 154B, 29 also. When our election was conducted, one of the department person, that cooperative department person, he told us that there is a provision that you can stop the facilities like water for that particular member after notice. However, you have to make a common tap in the society premises so that at least their essential water requirement cannot be avoided. Is there any circular or is there any provision or a case law regarding this?
No, to my knowledge, no such circular.
I was also having doubt about that. That's why I asked.
To my knowledge, no such circular.
So can we stop the services? I think no.
No, you cannot stop the essential services.
Okay, thank you.
Madam, can I ask one question?
Yes, sir. Yes, Mr. Bharat, please.
Yeah, thank you. Sir,
you can start your video as well.
Yeah. Sir, there are sir, there are various ways of transfer under the amended act now. So whether nomination will prevail or the heirship certificate or provide will prevail. One is the society has to consider the nomination, or they have to consider the what is the mandate of the heirship certificate, and accordingly transfer the name of the heirs in on the death of the original member.
Sir, see, so far as regard nomination is concerned,
Yes.
that would provide the concerned nominee only provisional membership.
Yes, sir.
And when the other legal heirs get the legal heirship certificate, or even if the nominee says
Yes.
the legal heirship certificate or some other testamentary document or some
Yes.
other order from the competent court,
Correct.
then that would be considered over the nomination and not otherwise.
So nomination will be treated secondary value. What will be considered would be first of all the formal document.
Would weigh secondary only after such document or order is
Obtained. Very well, sir. Okay.
Hello.
Yes. Hello.
I
Hello.
think that's all, sir. Anyone
Okay,
has
thank
any
you.
questions? No. Now I will request Mr. Makran.
Hello.
Please share your RERA group link.
Link is pasted in the chat box, ma'am. Please check.
No, I cannot see, ma'am. It is not visible. Not visible.
Okay, I'll again
Hello.
share. Please mute yourself.
Yeah.
Mr. Makran,
Yes.
you proceed with the vote of thanks.
Hello. Yes.
Hello.
Very good afternoon to everybody. Yeah. Hello.
Yes.
We have come to an end of our today's webinar, sir. Thank you very much. May I request all the participants to mute their voice, please? So
Wait a minute. I'll
that,
mute everybody. You
the
unmute
sweet,
yourself.
right.
Just a minute. Just a minute.
Hello.
Yes.
Yes, thank you very much, sir. It was really enlightening, session, especially in the lights of Maharashtra Co-operative Societies Act and with the current section amendment, like section 154B. You not only throw the light from the formation of the society till it's winding up, and you dealt with the major aspect as to what are the types of members and how the membership is to be transferred. And I think in the current situation, when most of our clients would want to secure their properties, it would be really helpful for client as well as all the property owners. So it was really a wonderful webinar. It was very informative, and I thank you very much from our RERA study circle. I would also like to thank all the participants. Hello.
Yes, you are visible. Yes,
Hello.
you can continue.
I would also like to participate. Hello. I would like to thank all the participants for their overwhelming response. What I would suggest is, in case if any participant have any query, you please log on to our Facebook page, leave your query there, and in case we will definitely get back to you on this. Thanks everybody. Thanks a lot, sir, and have a wonderful Sunday.
Thank you very much, sir.
Yes, please, sir.
Thank you very much, sir.
Thank you for inviting me
Yes.
and giving me this opportunity of presenting myself and expressing my views to you all. So nice of you, and thank you very much.
Thank you, sir. It is our pleasure.
Yes. Thank you, sir.
Thank you.
Thank you.